My name is Saket Sharma and I work as a research fellow in CUTS Institute for Regulation and Competition. There my work profile includes researching and lecturing in areas related to competition law, intellectual property law. Today I will be talking about module 13, which relates to horizontal agreements in United States of America and European Union. So to give you an overview of this module will deal with the regulation of horizontal agreements in EU and USA. European Union and USA are mature jurisdictions which have got good experience of dealing with the anti-competitive agreements, and we can really take out very good principles. We can have good learning principles from these mature jurisdictions and can apply those principles in competition law in developing economies also. So, USA is one of the oldest jurisdictions. First of all, we will deal with the horizontal agreements in USA. We will talk about the legal regime. We will talk about the standard of analysis. We will talk about the per se and rule of reason approach, and we will talk about what are the exemptions which are given in the antitrust law. And we will also talk about how the horizontal agreements, which are known as cartels, are given prominence, and what are the various programs, what are the leniency programs which have been developed in USA to fight and detect cartels. In the same way, then we will focus on how horizontal agreements are being dealt in European Union, and what is the legal regime, what are the tests, what are the standard of analysis, and what are the exemptions, and how they deal with fighting cartels in European Union. In the end, briefly we will compare what are the approaches, what is the comparison, what is the difference and similarities in the approaches of the EU and US. So friends, I will begin with US first. Antitrust laws, as they are called in US, generally we call it competition law elsewhere. So antitrust laws in US and Sherman Act particular are called the Magna Carta of free enterprise in US. They are as important as preservation of economic freedom, and they have been called economic constitution of that country. So moving on to horizontal agreements in USA, Sherman Act is the oldest act. It's of 1890, and Section 1 of the Sherman Act prohibits every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states with foreign nations. So the section refers to contracts, combinations, or conspiracies in restraint of trade. Therefore, a concerted act of action between two or more separate persons or entities need to be shown. So we can really see what are the important ingredients of Section 1 of the Sherman Act. First is there must be an agreement or conspiracy between at least two parties. The next is analyzing the competitive impact of the restraint, the specific business practice which is in question. So, and there must be direct or circumstantial. The correct standard is that there must be evidence that tends to exclude the possibility of independent action by the parties. And a standard has emerged in way back in 1984 Supreme Court of United States in Monsanto Company versus case. It laid down a standard, and it said that direct or circumstantial evidence that reasonably tends to prove that the parties had a conscious commitment to a common scheme. So this conscious commitment to a common scheme should be designed to achieve an unlawful objective. So this is the standard. In Copperweld case, the US Supreme Court has already made it clear that a corporation cannot be found guilty or held liable for conspiring with an unincorporated division. So parallel conduct alone doesn't establish a conspiracy. There must be something more than conscious parallelism which needs to be shown. And these factors which are more than the parallelism, these are called plus factors. And if we want to take the examples of such plus factors which need to be shown for proving that the agreement is anti-competitive, so these plus factors can be price fixing conspiracy, evidence that the defendant acted contrary to its interests, and evidence implying a traditional conspiracy. So there can be two types of evidence, and as we have already talked about, it needs to show that there is non-competitive behavior in the market. So if we take an example of a case law here, and we take an example of Puerto Rico optometrist group, which was a classical case of price fixing conspiracy. In this case, a not-profit association of optometrists which were practicing in Puerto Rico, and they were about a 500 member group. There were the allegations that the association and some of its office bearers were violating the antitrust rules by facilitating negotiations, and some of its office bearers were entering into express or implied agreements among the members to refuse or threaten to refuse to accept healthcare contracts except on collectively agreed upon terms. So the FTC, the Federal Trade Commission, consent order settling these charges barred the groups and the leaders of the association from engaging in such collective boycott. So that was a classical case. So if we move to what is the standard of analysis in the Section 1 of the Sherman Act. So it is rooted basically in criminal law, as you might know, that cartelization is also a criminal offense in US, and therefore a higher degree of proof is warranted. All the US courts have developed a rule of reason approach, which is based on old common law doctrine of ancillary restraints in Standard Oil case in 1911, in which it was held that only unreasonable restraints should be illegal. So under the rule of reason, the pro and anti-competitive effects of the agreements are weighed against each other in order to determine whether the agreement in question enhances or reduces competition. Agreements do not need to be formal in writing, but there must be a conscious commitment to a common scheme, which I have already told you, which was decided in the US case in 1984. So next, we will deal with the standard of analysis. What is the standard of analysis in the Section 1 of the Sherman Act? So as you know, the Section 1 of the Sherman Act is rooted in the criminal law. Thus, there is a higher standard of proof which is warranted. And US courts have developed a rule of reason approach. And in 1911, in the Standard Oil case, it was held that only undue or unreasonable restraints should be illegal. So as Justice Brandeis pointed out almost 100 years ago, every agreement concerning trade, every regulation of trade restraints. To bind to restrain is of the essence of an agreement. So the true test of legality is whether the restraint imposed is such as merely regulates and perhaps thereby promotes competition, or whether it may suppress or even destroy competition. To determine this, the courts look at facts specific to the business, the situation before and after the constraint was put in place, and the nature of restraints as well as their actual or probable effect. But have you seen in horizontal agreements, there is more per se approach which is used. So the one rule is rule of reason, the other is per se approach. The per se approach implies that cases when the nature and necessary effect of restraint is plainly anti-competitive, that it should be treated unlawful per se. In such cases, an elaborate inquiry into the restraints is not required. And in US, per se rule refers to categories of behavior which are presumed to be an unreasonable restraint of trade, and thus they are anti-competitive. Such reasons of treating them stringent include, and they have been labeled as naked restraints which are manifestly anti-competitive, they are pernicious, or by their stating, And the courts have reasonable experience of dealing with such sort of restraints. And such and the experience of the court suggests that horizontal market agreements among competitors should be treated as per se. Such acts includes price fixing, geographic market division, group boycotts, and tying arrangements. So you can see that these pernicious effect on competition and lack of any redeeming economic value and agreements, these price fixing agreements are treated as per se anti-competitive. And therefore there is no need to go into elaborate inquiry into such type of agreements. The example of such agreements can be the lysine and citric acid cartels. So in this case, there was an international price fixing and volume allocation agreement among the world's major producers of lysine. And lysine is a feed additive used by farmers for livestock feeds. So this price fixing, this was an international agreement, and this affected a large number of nations. And in this, a joint effort by antitrust divisions of US Department of Justice and Federal Bureau of Investigation resulted in the conviction of 5 companies and 6 of their executives and heavy criminal fines. So you can see that there are heavy criminal fines if you are indulging into price fixing cartels. On the other hand, rule of reason approach, which we'll discuss very briefly here, that has also emerged, and that under the rule of reason, a detailed inquiry of pro-competitive and anti-competitive effects is taken care of. And there will be a case-by-case evaluation where all the circumstances of a case are taken care of in deciding whether the restrictive practice should be prohibited or not. So the balancing is what is needed. We will also briefly touch upon the third approach which has developed recently, and that is called quick look approach. And this quick look approach can be called in the abbreviated version of the rule of reason, in which proof of actual market injury such as sustained supra-competitive prices or reduced output obviates the need for more rigorous market-based analysis. Now we'll move to what is the treatment which being given to joint ventures under Section 1. So normally joint ventures are analyzed under Section 1 of the Sherman Act using the rule of reason. Thus it needs to be determined whether the venture can lead to the exercise of market power, and if so, whether anti-competitive aspects outweigh any pro-competitive benefits, which we already told you. 3 additional factors which need to be taken care of while analyzing the joint factors. First is openness, sharing of risk, and the increased efficiency due to the joint ventures. So you have seen that horizontal agreements, including cartels, have been given a stringent treatment. But there are some business practices which can be beneficial to competition, as we've already told regarding the joint ventures. So in US antitrust law exempts some of these actions, and some of these exemptions have developed judicially, and some of them are given by the law. And so there are 2 broad sources of the exemptions. And if we see at the legal statutes, the examples include Webb-Pomeranian Act of 1918, which provides an exemption for exporting cartels. And there is Copperweld Act of 1922, which provides exemption for agriculture cooperatives in US. So, and there is exemption for labor unions also from the Antitrust Act in the United States of America. And there is judicially created doctrines like field rate doctrine, which also applies. And if a business which has been regulated and which files its prices for approval by a regulatory agency, then that business is eligible for immunity from the antitrust laws in the US, and specifically the Sherman Act. So state action doctrine, which is a judicially created exemption, And in that case, if the action takes place under the state regulator's active supervision or law that clearly provides for the approval of restraint, then such an action is exempted. And we can see an example of exemption in the 2107 case of US Supreme Court, in which Securities Exchange Act of 1934, which regulates the securities trading in the US, and that fall within the exemption of the antitrust laws in US. So you can see that we have covered till now exemptions also, and what are the basic treatment being given to the cartels in the US. Now we'll move on to very important aspect of US, which is the leniency program, which has been devised to detect and fight cartels. So the most important aspect of a cartel detection is the leniency program. Department of Justice administers these programs, and it is applied even to criminals violations which fall under Section 1 of the Sherman Act. And Antitrust Division has a long-standing policy of seeking criminal indictments. So in USA, the leniency program basically comprises of two policies. The first was the corporate leniency policy, which was first introduced in 1978 and revised in 1993. And second is individual leniency policy, which was introduced in 1994. Again, the corporate leniency policy is divided into two types, which is type A leniency policy and type B. So type A leniency offers immunity from prosecution when applicant is first to approach, and there are some conditions which need to be met. The first is that the Antitrust Division has not received information about that illegal activity from any other source. The second is there should be discovery of the company took some prompt steps after the discovery of illegal activity, and the company reports the wrongdoing and complete wrongdoing to the authority. And wherever possible, the company makes restitution to the injured parties. So type B leniency offers immunity from prosecution when an applicant is first to approach the Antitrust Division after an investigation. And in this case, the company is first to come forward and qualify for leniency. So this was the leniency policy we were discussing. And now US legal frame also incorporates amnesty plus and penalty plus for better detection of cartels. Under amnesty plus, for example, the Antitrust Division will give a benefit to company being investigated for criminal activity in product market X for any criminal activity in another market also. So this way, this is the reason why it's called amnesty plus. And so leniency program is very important aspect of the cartel detection and cartel fighting. And if you take the examples of recent of 2014, Bridgestone Corporation agreed to plead guilty and pay a criminal fine of $425 million for its role in price fixing automotive rubber parts. So you can see that there are some of the cases in which the companies come forward and they take the benefit of leniency policy. So there are very high implications of if a company is found guilty, because it is a criminal. There are criminal sanctions as well as heavy fines attached to the violators. Criminal prosecutions are typically limited to intentional and clear violations, such as when competitors fix prices or rig bids. And the violations are punishable with fines up to $100 million for corporations or $1 million for individuals. And there can be imprisonments for up to 10 years, or there can be fines plus imprisonments, both. But it has been seen that Department of Justice proceeds criminal cases in criminal sanctions only when it involves hardcore offenses like we have already discussed. Further, under Clayton Act, any person injured by violation of antitrust laws may file a suit to recover the treble damages and for injunctive relief also. Thus, one can really see the mix of public and private enforcement in US. And so this was all about US. So after discussing the basics of horizontal agreements and all the approach of the United States of America towards the hardcore cartels, now we'll shift to the horizontal agreements in the legal framework of the legal treatment which is given to horizontal agreements in European Union. As you know, European Union is made up of 28 member countries, and a treaty is binding between these member countries to set out the EU objectives and rules under which they work inter se. So the competition provisions of EU were earlier established in Treaty of Rome, which is called, and which was entered into force in 1958. The current regulation, which lays down rules implementing the provisions for the current treaty, is Treaty of Functioning of European Union, which is also called Treaty of Lisbon, and which was entered in force in 2009. So Regulation 1 of 2003 laid down the rules for implementing 2009 Lisbon Treaty, and Article 101 deals with the agreements. So now we'll focus on what are the main ingredients of these articles. So Article 101, Clause 1 prohibits any agreement or concerted practice between undertakings or decisions of an association or undertakings which has its object or effect the prevention, restriction or distortion of competition, and which has an effect on trade between European Union member states. So object and effect test is a very important aspect of Article 101. Article 101 can be applied to horizontal as well as vertical agreements, but our focus here will be on horizontal agreements. So, three kinds of conducts that are prohibited under the article. First is the agreements between undertakings, decisions of associations of undertakings, and concerted practices. And you can very well see that there is a considerable overlap between these set of practices. Article 101 thus is an illustrative and non-exhaustive list of agreements which can be caught, such as price fixing and market sharing. And agreements covered under Article 101 are void and unenforceable, and may also attract fines unless they satisfy the criteria which is given in Article 101 Clause 3. So, existence of undertaking or association of undertaking needs to be shown. Then one needs to show that there was a collusion. There is an agreement between undertakings, and collusion having object or effect of prevention, restriction or distortion of competition. Next thing which needs to be proved is that effect is appreciable effect on competition between the member states. So what is the standard of analysis basically? There are two steps. First step is under Article 101 Clause 1 is to assess whether an agreement between undertakings is capable of affecting trade between member states, has an anti-competitive object, or actual or potential restrictive effects on competition. And the second step comes into play only when the agreement is found restrictive, and that second step deals with Article 101 Clause 3, and there we need to determine the pro-competitive benefits, if any, produced by such type of agreements, and then we need to balance if the negative effects on competition and pro-competitive effects on competition. So what we need to analyze is what is the balance between. So object or effect of restricting competition. This is what normally horizontal agreements or cartels like price fixing or bid rigging by their object are seen as anti-competitive. The word object implies meaning and purpose of the agreement considered in the economic context, and one can see that object and effect are not cumulative conditions. If it is proved that the object of an agreement is to restrict competition, then it is very sure that Article 101 is infringed, but we do have recourse to Article 101 Clause 3. Recent cases, we see the recent cases of 2014 this year only. EU Commission found 3 producers of canned mushroom which were indulging in price fixing activities, and they were fined heavily. So there have been many cases where such price fixing cartels have been punished. And if we take one more example, power exchanges were fined. And these were 2 leading European spot power exchanges, and they agreed not to compete with each other for their spot electricity trading services in European Economic Area, and they were fined heavily because of indulging in such anti-competitive effect. One other important aspect is the appreciable effect on competition, and here we see the de minimis rule. So if this doctrine of de minimis, which stems from a earlier case, Volk case decided by European Court of Justice, this provides a safe harbor for minor agreements between companies which are below certain market share thresholds. Agreements between actual or potential competitors benefit from the safe harbor provided that the agreement market share held by the parties to the agreement doesn't exceed 10% on any of the markets affected by the agreement. And agreements between companies that operate at different levels of the supply chain, which are mostly covered in the distribution agreements, the market share for such safe harbor is 15%. The EU Commission guidance on de minimis has been recently revised in 2014 and they have come out with a new notice on that, and they have taken note of the Expedia case and they have incorporated that the judgment of the Expedia case. The revised notice therefore incorporates a strict approach to the agreements having their object to restrict competition, which are mostly, as we have seen, are the horizontal agreements. So what exactly is Article 101 Clause 3? What is the criteria under Article 101 Clause 3? There are 4 conditions which needs to be satisfied. First relates to efficiency gains, second relates to fair share for consumers, and third relates to indispensability of the restrictions, and last is there should not be any elimination of competition. So these 4 conditions, which are listed in specifically in Article 101 Clause 3, needs to be fulfilled if firms want their agreements to be exempted from the Article 101. Let me give you an example of how these conditions are applied, and let me take an example of last year in 2013 case in which EU Commission in the Star Alliance case applied these things. That was an alliance between Air Services, the Continental United, Lufthansa, Air Canada, and on 6 routes. The Commission took the preliminary view that they are indulging in anti-competitive practices and such collaboration eliminated competition. But after analyzing it through Article 101 Clause 3, the Commission accepted the efficiencies which were given by the parties, and the Commission accepted their argument, and out of 6 in 5 routes the Commission said that these agreements improved efficiency and it won't restrict but it will promote competition. But only in one route the Commission said that those price fixing and those capacity fixing agreements might go against competition, and in that specific route, which was Frankfurt-New York route, the Commission asked those companies to modify their agreements. So moving to the next thing, we will cover the system of block exemptions, which is specific to the European Union. So there are specific exemptions for specific categories of agreements and specified sectors. These are generally called block exemptions. And such examples include block exemption for specialization agreements, block exemption for research and development, and it can be specifically for certain sectors also, like for airline industry, there's an, or for insurance sector also. So what are the reason for why we need such block exemption in European Union? What is the reason behind designing such exemptions? These exemptions describe the typical features of the agreements in the sector covered by the regulation and further describe the specific criteria the agreements must conform to qualify for exemptions. So there are guidelines given by the Commission, sector specific, and if the agreement falls under that criteria, that agreements fall under the exemption. So this also needs a very detailed analysis of the agreement and if it falls under that specific exemption. So moving on to next important thing which we already did in case of US and now we'll do it in the case of European Union is the leniency program, the leniency policy for detection and for fighting cartels. The EU leniency policy was first introduced in 1996 and revised. It has been revised twice. So it is like it was first revised in 2002 and then in 2006. So the last revision took place in 2006, and the EU Commission can grant immunity from any fine that otherwise would be imposed on an undertaking that discloses to the Commission its participation in a cartel affecting the European Union, provided that the undertaking is first to submit information and evidence. And there are other conditions also which need to be satisfied. The applicant for immunity must cooperate genuinely, fully, expeditiously, and on a continuous basis. The applicant must not disclose the fact of the contents of application to any other. Anyone before the Commission has issued a statement of objections. The applicant must not destroy or falsify or try to conceal the evidence. And the applicant must not have coerced other parties to join the agreement. So there are specific conditions under the leniency policy, and if an applicant qualifies, that applicant can get full immunity from them. Also important to see that applicant should also end its cooperation with other cartel participants and should fully cooperate with the Commission. There's also, if there's a second applicant, and then there's a provision that the fines can be reduction to 50%, fines can be reduced to 30% to the third applicant. So there's subsequent reduction of fines when there are more applicants joining in. So leniency program has really helped in detection of some of the cartels, and if we take an example of the cathode ray tubes cartel, in 2012 the European Union Commission imposed a heavy fine on 7 producers of cathode ray tubes. So cathode ray tubes are used in TVs and computers, and there was price fixing international cartels. In this case, the Commission identified separate cartels for CRTs for TVs and computers and found various companies violating this, violating the competition law norms. And the company received full immunity from fines under the Commission's 2006 leniency policy because it was first to come and first to apply for the leniency. And some of the companies later on got reductions in fines as like from 40% to 30%, keeping in view their timing and their cooperation with the Commission. So you can see the leniency program is very helpful in detection and fight of cartels. Lastly, we will cover what are the implications and sanctions under the EU of if you indulge in horizontal agreements and horizontal practices like cartelization. So first thing is the agreement will be automatically void. Next, there will be risk of civil damages and claims by the victims. Well, till now the EU Commission doesn't have the jurisdiction to impose criminal sanctions, but the EU Commission can give a prohibition decision in accordance with Article 7 of the regulation, and there can be a commitment decision also under Article 9 of the regulation. So there is a proper fining penalty guidelines also devised in EU, and the fines are levied keeping in view those guidelines, which are quite very clear. The settlement procedure for cartels is also a new thing which was introduced in 2008, and this allows EU Commission to apply a simplified procedure when companies acknowledge their participation in infringement and their liability for it. And this reduces the length of investigations and therefore benefits consumers also. And because it reduces costs, it's good for enforcement, it frees up resources. So settlement procedure, as we've already discussed, is also one of the very important aspects of European Union policy to detect cartels. And first settlement decision in EU was in 2010, which was related to digital dynamic random access memory. So there was a cartel, there was price-fixing cartel, which was going on since 1998 to 2002. And in this case, this was the first settlement decision in which EU fined about 10 producers of DRAMs. So one can see that in European Union, a rigorous enforcement action approach has started. So there are heavy penalties. One can see it as a carrot and stick approach. There are heavy fines, and there are leniency program also. So if you apply, you can benefit from the leniency program. So it sort of helps companies come. So it helps companies to come forward and file for a leniency application, and this way the Commission also gets benefit to easily detect the cartels. So this was what we covered specifically related to horizontal agreements in European Union. So in this module we covered US and EU jurisdiction and the treatment given to the horizontal agreements and specifically to the cartels in these jurisdictions. And if we compare very briefly, it's pertinent to compare what are the comparison which comes out of these two jurisdictions. First thing is, in US there are criminal sanctions also to these hardcore cartels, and in EU this is not the case. And in European Union there is no concept of treble damages, and in US I have already told you that there is a concept of treble damages. And if one looks at the recent enforcement actions in EU and US, one can see there is convergence coming in this area, and the convergence is more in the form of information sharing and joint efforts to detect cartels. So this shows that this important area of competition law enforcement, and due to this there is a lot of collaboration between EU and US, and we have seen a very hardline approach coming in from both of these jurisdictions to deal with the problem of hardcore cartels, which are of course one type of horizontal agreements. And the international cooperation for enforcement measures to check these international cartels has also increased. And so you have covered what is the legal framework to analyze the horizontal agreements in EU and USA, cartels which is the core, the hardcore cartels which are seen as one of the pernicious anti-competitive activities are given hard treatment, and now we are moving towards harsh and very heavy fines to the cartel participants. And on the other hand, we have leniency policy to check and to facilitate if member of cartel wants to come forward and admit his mistakes. So this was all which we tend to cover in this module dealing with horizontal agreements in European Union and USA. So good luck to all the students for their further, and you will like to see the module and visit the reference parts to see what there, because there is a list of further references, and if you would like to do further reading on the subject, then you can go and check the modules. Thanks.